It's really different in different situations. Each situation has its own unique set of circumstances. Typically, when there's a petition filed in family court for custody, for example, the judge will often appoint a law guardian, which is a lawyer to represent the children involved. And then both parents have a right to an attorney in custody and visitation issues. But, you know, it's really, the judge doesn't always have that information available to him unless one of the parties presents it to the court. Like, this is the history of domestic violence here. But don't forget also that there's also a significant amount of unreported incidents. There's probably usually always a handful of incidents that take place before the first phone call is made reaching out to the police. So for, you know, every one police report, there's probably been a handful of incidents that have taken place. You know, so it would be up to one of the parties to present that information to the court. And then, you know, the judge has a really difficult time of, you know, making decisions as far as what the future of this family is going to look like. What is the visitation going to look like? What's going to keep mom and children safe, or the non-offending parent and the children safe? So, you know, as far as, you know, when we accompany victims of domestic violence to court, we try to prepare them as much as possible for what, you know, what might possibly happen, or, you know, what the different multiple outcomes might be. But to be able to talk with a victim and say, listen, there's a long history of domestic violence here. There's no way that you're going to end up, there's no way that you're not going to end up with custody, because that's just not true. You know, we've seen the typical thing that I've seen is like joint legal custody and then physical custody to one parent or the other. But, you know, that's never a guarantee either.